Let me stop you right there. Whatever you were doing today, whatever was on your mind when you clicked on this video, I need you to put it aside for the next few minutes, because what I am about to tell you is the most significant thing that has happened to gun owners in this country in decades. I am not exaggerating. I am not clickbaiting. I am telling you that the Supreme Court of the United States has just moved into emergency mode on a series of rulings that could completely wipe out firearm permit requirements across all 50 states. Gone, done, over. And the craziest part, the decisions are moving faster than anyone expected, and the reaction from state governments has been absolutely chaotic. Some states are scrambling to comply, others are already cooking up what legal experts are calling workaround legislation, trying to replace permits with something that looks different but functions exactly the same. And sitting in the middle of all of this is you, the everyday gun owner, trying to figure out what this actually means for your rights, your carry status, and your legal protection starting right now. By the time you finish this video, you are going to know exactly where things stand, exactly what the courts are doing and why, and exactly what you need to do next. Let us get into it. To really understand how big this moment is, you have to understand how bad the situation got before it happened. For over 100 years, certain states have been building permit systems that effectively put your Second Amendment rights behind a government paywall, and I do not use that term loosely. I mean it literally. Think about what it actually costs a regular working person to legally carry a firearm in a state like California, New York, Hawaii, or New Jersey. You are paying application fees that can run anywhere from $100 to over $400 depending on the county. You are taking mandatory training courses that cost another $200 to $500 if you can even find an approved instructor with an open slot. You are taking time off work to submit paperwork, show up for interviews in some jurisdictions, wait for background investigations that can drag on for 6 months or longer, and then, after all of that, you can still get denied. No clear reason given, no real appeal process, just denied. Try again, pay again, wait again. And here is the part that made this situation truly indefensible. The people grinding through that system were not criminals. Criminals do not apply for permits. They never did. The only people navigating hundreds of dollars in fees and months of waiting are law-abiding citizens who wanted to protect themselves and their families the legal way. While they were waiting on government approval, the people who actually meant to harm them were not waiting on anything. That fundamental injustice is what gun rights organizations spent years building a legal case around. And that case is what just exploded into this moment. Then, after the Bruin decision came down in 2022, something unexpected happened. Instead of accepting the ruling and adjusting their laws, several of the most restrictive states got creative. They said, fine, we will technically issue permits, but we will make those permits functionally useless. And they did it through what legal experts have started calling vampire rules. The name fits perfectly. A vampire cannot enter your home unless invited. Under these new state laws, a permit holder could not enter any private property open to the public unless the owner had an explicit sign saying firearms were welcome. Think about what that actually means in practice. No sign at the gas station? Felony? No sign at the grocery store? Felony? No sign at the pharmacy where you pick up your prescriptions? Felony. These states turned the entire constitutional framework on its head. Instead of your right being the default and restriction being the exception, they made you a presumed criminal the moment you stepped off a public sidewalk. If you have a permit but cannot walk down a normal street without crossing an invisible legal line that turns you into a felon, you do not actually have a right. You have a laminated piece of plastic that means nothing. That is the setup. That is the injustice that built up over decades and that the courts are now being forced to dismantle. And the way it is being dismantled right now is unlike anything we have seen in modern Second Amendment history. A coalition of gun rights organizations filed sweeping federal lawsuits targeting these permit systems directly. The arguments were not complicated. They were actually beautifully simple. The Constitution says the right to keep and bear arms shall not be infringed. Forcing citizens to pay hundreds of dollars, wait 6 months, and pass through multiple layers of discretionary government approval before exercising that right is, by any reasonable definition, an infringement. The courts have long held that you do not need a government permit to speak freely. You do not need to pay a fee to practice your religion. You do not need to wait 6 months before a state official decides whether your Fourth Amendment rights apply to you today. So why has the Second Amendment been treated as a privilege that the government can charge for, delay, and deny, while every other enumerated right operates as an immediate presumed protection? That question moved through the lower courts faster than expected. It landed in front of the Supreme Court, and the court did something that sent a very clear signal to everyone watching. It fast-tracked the cases. When the Supreme Court accelerates its timeline on a constitutional question, it is not a procedural quirk. It is a message. It means the justices believe that people are being actively harmed right now and that the question is too urgent to sit in a slow-moving queue. The case that has become the centerpiece of this fight is Woolford versus Lopez, which directly challenges the vampire rules that states like Hawaii and New York implemented after Bruin. The Supreme Court heard oral arguments on an accelerated basis, and what happened inside that courtroom was a turning point that most of the mainstream media either missed or chose to downplay. Both sides came prepared, but they did not come equally prepared. The lawyers representing the gun rights coalition walked in with a mountain of documented evidence. They had data from the more than 24 states that had already moved to permitless carry over the past 15 years, and that data showed something that permit defenders absolutely could not explain away. In state after state where permit requirements were removed, the predicted explosion in gun violence simply never happened. Crime rates stayed flat. In several cases, certain categories of violent crime actually declined as lawful carry became more accessible. The data was not cherry-picked from friendly sources. It came from state crime reporting systems, FBI uniform crime reports, and independent academic research that had been reviewed and validated. They also brought something that data alone cannot always deliver. They brought real stories from real people. There was a woman, a single mother working 2 jobs in a high-crime neighborhood, who applied for a carry permit after her home was broken into. She was denied because a permit officer decided her documented threat environment was not sufficiently compelling. She could not afford a lawyer to appeal. She could not afford to reapply. She went without protection not because she was not qualified, not because she was a danger to anyone, but because the system was deliberately designed to make protection a luxury that working people could not access. Her story was one of dozens submitted into the record, and those stories did something the statistics could not do on their own. They put a human face on what government obstruction of a constitutional right actually looks like when it lands on someone's doorstep. The lawyers defending the permit systems tried to hold their ground by arguing that states need flexibility. They said the situations in rural Montana and downtown Honolulu are too different to be governed by the same constitutional standard. But when a justice pressed them on that logic directly, the argument fell apart immediately. Constitutional rights do not come with geographic asterisks. Your First Amendment rights do not shrink because you live in a dense city. Your right to a jury trial does not weaken based on your zip code. The Second Amendment was never written to be strong in some places and weak in others, and the justices sitting in that courtroom made clear they were not interested in pretending otherwise. Then the states tried the historical argument. Under the Bruin test, states have to prove that their gun restrictions are consistent with the historical tradition of the United States as it existed in 1791, and they are failing that test in stunning and sometimes embarrassing fashion. The state of Hawaii, when pressed to provide historical precedent for its modern permit restrictions, actually cited a black code law from 1865 Louisiana. A law that was specifically written to disarm formerly enslaved people after the Civil War. That was their historical evidence. That was the best they could find to justify keeping ordinary citizens disarmed today. Justice Gorsuch called them out directly, asking why the court should rely on a law that was designed to suppress civil rights as its model for modern constitutional governance. When your legal defense rests on some of the most shameful and racist statutes in American history, you have already lost the moral argument, and you are in serious trouble on the legal one. The moment that cut through everything came when a justice posed one single direct question to the pro-permit side. Can you show the court peer-reviewed evidence that permit requirements have meaningfully reduced violent crime in any state? The room went quiet, because the answer is no. That evidence does not exist. The permit defenders pointed to op-eds and advocacy position papers, but they had no hard data. None. Meanwhile, the other side had years of real-world results from states where permits had been eliminated and the predicted catastrophe never materialized. That contrast between one side with documented outcomes and another side with political arguments defined the entire proceeding and clearly shaped where this is headed. And then came the plot twist that almost nobody saw coming. The Department of Justice, in briefs filed ahead of the arguments, took a position that stunned legal observers on both sides. The DOJ, the same federal body that typically fights to defend government regulatory authority at every level, began conceding ground. They started acknowledging that these overlapping permit systems had become so complex, so expensive, and so riddled with sensitive place bans and administrative delays that they effectively nullify the right to carry rather than regulate it. The DOJ pointed to federal background check data showing that the existing NICS system already screens out prohibited buyers at the point of sale. State permit layers, they argued, were not adding a meaningful safety benefit. They were adding a tax on constitutional rights, and that tax falls hardest on low-income Americans who cannot afford the fees, the mandatory courses, or the months of lost time. When the federal government's own lawyers walk into the Supreme Court and signal that state gun restrictions have crossed a constitutional line, that is not something you see every day. That is a tectonic shift in the legal landscape. There is also a secondary piece of this fight that deserves your attention because it is moving on a parallel track. The Supreme Court has been examining what happens when the administrative machinery of the permit system itself is used as a weapon. This is the administrative delay trap. States like New Jersey and Illinois mastered this technique. They do not officially deny you. They just lose your paperwork. They tell you the background check is pending. They schedule your interview and then reschedule it. 6 months becomes a year. A year becomes 18 months. You are never denied, so you have no denial to appeal. You are just permanently suspended in bureaucratic limbo, while your constitutional right sits in a drawer somewhere collecting dust. The court is treating this pattern as what legal experts call a constructive denial of a fundamental right. The emerging expectation from legal analysts tracking these arguments is that any final ruling is likely to include language establishing hard processing deadlines. If a state cannot complete its review of a law-abiding citizen within a defined window, the default shifts to the citizen, not the government. No more weaponized waiting, no more disappearing paperwork. Either prove the person is prohibited right now or get out of their way. Now let us talk about the sensitive places question, because this is the other pillar that anti-gun states built their entire post-Bruin strategy around, and it is crumbling faster than state attorneys general expected. After the Bruin ruling, the strategy in states like California, New York, and Hawaii was clear. Fine, they said, we will give you the permit, but we are going to make it illegal to actually use it anywhere by declaring almost every public space a sensitive location where carry is prohibited. They did not stop at schools and courthouses. They tried to declare parks sensitive, beaches sensitive, sidewalks sensitive, restaurants, banks, public transit, entertainment venues, and in some cases the area immediately surrounding government buildings, which in dense cities means entire city blocks. The effect was the same as the vampire rules. A permit that exists on paper but cannot be exercised anywhere in the real world is not a right. It is a bureaucratic fiction designed to look like compliance while achieving the same result as an outright ban. During the Wolford arguments, Justices Thomas and Alito were openly skeptical of the state's sensitive place expansion strategy. The states were asked a simple question: show the court historical laws from 1791 that prohibited carrying firearms in grocery stores, on public transit, or on the open street in front of a private business. That list does not exist, because the founders understood something that these modern state laws deliberately ignore. A right that you cannot exercise in public is not a right at all. It is a conditional permission slip that the government can revoke by simply declaring the space around you off limits. If the court strikes down the expanded sensitive places framework and the oral arguments suggest that is exactly where this is heading, the foundational logic of the modern permit trap collapses entirely. There is something else happening inside the Department of Justice that goes even deeper than the public filings. Legal observers who track internal DOJ communications have noted what appears to be a genuine internal division between career officials and department leadership over how aggressively to defend state permit systems. Some career staff reportedly wanted to maintain the traditional DOJ posture of defending government regulatory authority across the board. But leadership, reading the direction of the court clearly, began pulling back from the most indefensible positions. The result is a DOJ that is no longer the reliable ally that restrictive states were counting on. States that built their entire legal defense around the assumption that federal lawyers would stand beside them are discovering that those lawyers are quietly stepping back, leaving the states to defend their most extreme permit structures on their own. That strategic retreat by the DOJ is not a small thing. It is a signal that even the institutions that historically supported permit systems have concluded that the most restrictive versions of those systems cannot survive the current court's scrutiny. When your most powerful ally stops showing up to the fight, you are in serious trouble. There is also a critically important question in front of the court right now regarding what happens when you cross a state line. Today we live under a patchwork of laws that makes legal gun ownership a geographic lottery. You can be a completely lawful gun owner in one state and become a felon the moment you cross into the next one because that state does not recognize your permit or your carry rights. The legal argument building around the 14th Amendment is straightforward. If the Second Amendment is a fundamental individual right, then it must travel with you the way your other fundamental rights do. Your right to free speech does not vanish when you drive from one state to another. Your Fourth Amendment protection against unreasonable searches does not have a GPS trigger that shuts it off when you cross a border. So why does your right to self-defense have a zip code? The answer, legally speaking, is that it should not. And the court's current direction suggests that a national standard for carry recognition is no longer a distant dream. It is a foreseeable legal outcome of the path these cases are cutting. So where does all of this actually land for you as a gun owner right now? Here is the practical reality. Legal experts tracking the Supreme Court's current docket are circling late June 2026 as the most likely window for a major ruling, based on the timing of oral arguments in Wilford v. Lopez and the court's standard opinion release schedule. However, because the court treated this as a priority case and has already signaled urgency through its accelerated timeline, some analysts believe we could see a summary disposition or a broad ruling as early as late April or May. When that decision hits, it is going to hit fast. The vampire rules in Hawaii, California, and New York could be legally invalidated within hours of the opinion being published. That means you need to be ready before the ruling drops, not after. And here is the warning you need to hear clearly right now. Do not expect the restrictive states to simply accept this and move on. They will not. State attorneys general in California, New York, New Jersey, Illinois, and Hawaii have already begun drafting what legal observers are calling workaround legislation. The strategy is transparent. If direct permit requirements are struck down, replace them with something that functions identically but uses different vocabulary. Mandatory safety registration programs, carry certificates tied to insurance requirements, local law enforcement notification systems that introduce the same delays through different paperwork, training mandates designed to be logistically impossible to complete in any reasonable time frame. Different name, same obstruction. Gun rights organizations have publicly stated they are watching for exactly this kind of legislative maneuver, and that follow-up litigation is already being prepared for the moment these workaround laws are signed. The ruling is going to be massive, but it is going to be the beginning of the next legal fight, not the end of all fighting. There are also some things you need to be crystal clear about in terms of what this does not change, because there is already a significant amount of misinformation spreading, and some of it could get people into serious legal trouble. This is not a free pass to carry anywhere and do anything. Federal disqualifications still apply completely. Felony convictions, domestic violence convictions, active restraining orders, adjudicated mental illness, and all other federal prohibitions remain in full force. Background checks through licensed dealers are still required. Federal gun-free school zones are still in effect. Courthouses, federal buildings, airports, and other sensitive federal locations are still off limits. Private businesses retain the right to prohibit firearms on their property, and you are legally required to respect those policies. State laws regarding carrying while intoxicated, improper storage, brandishing, and use of force standards all remain fully in force. What changes, specifically and exclusively, is this. The government can no longer require you to seek its permission before exercising your constitutional right to carry for self-defense in places where you are otherwise legally allowed to be. That is the line. Do not blur it. While you are waiting for the ruling and processing what is already in motion, here is your 3-step action plan, because the people in this community do not just watch the news. They prepare. Step 1. Know your state's current official position. Most state attorneys general have issued public statements about how their state is responding to the legal developments already in motion. Do not rely on social media summaries, and do not rely on what someone told someone in a comment section. Go directly to your state government website and read the actual official language. The details matter enormously right now because things are moving fast, and the difference between what a state officially says and what is actually enforceable on the street can be significant during a period of legal transition. Know what your state is saying and know what it means for you specifically. Step 2. Audit and prepare your gear. If permit requirements are legally dismantled across the country, millions of new people are going to start carrying who previously could not afford or access the permit process. That is a good thing for self-defense rights, but it also means that the standard of responsibility in the lawful carry community needs to rise to match the moment. Make sure your holster is quality, secure, and appropriate for the firearm you carry. Make sure your carry method is consistent and that you have practiced drawing and reholstering enough that it is not something you have to think through in a high-stress situation. Make sure your firearm is properly maintained and that you are carrying ammunition appropriate for self-defense. Constitutional carry means personal responsibility is entirely on you. Act like it. Be the carrier who proves the critics wrong. Step 3. Double down on training. Here is something the permit debate has sometimes obscured. The permit was never what made you a responsible carrier. Knowledge, practice, and judgment made you a responsible carrier. If permit requirements are stripped away, that is not an invitation to carry without competence. It is actually the opposite. It is a call for the community of lawful gun owners to demonstrate through their behavior that constitutional carry produces safer, more responsible outcomes than the restrictive systems that are being dismantled. Take a quality course. Spend real time at the range. Understand your state's specific use of force laws inside and out. Know what to do and what not to do in the seconds after a defensive encounter. That knowledge is your actual protection, not paperwork, not a plastic card, knowledge and competence. Step 3. Carry your documentation and stay calm during the transition. Law enforcement at the ground level may not have received complete guidance yet on how their departments are implementing the legal changes already happening. Officers on patrol are working from the information and directives their departments have given them, and in a rapidly shifting legal environment, that information may be incomplete or out of date. If you are ever stopped or questioned, being cooperative, calm, and informed is always the right posture, regardless of what the law says. Have documentation of legal purchase. Know your rights without being confrontational about them. Be the person in the room who knows the law better than anyone else, and be the person who uses that knowledge to de-escalate, not to create conflict. Look, we are living through a genuinely historic moment for the Second Amendment. For over a century, law-abiding citizens have been told that their right to self-defense was conditional on how much money they had, conditional on how long they were willing to wait, conditional on whether a local official found their reasons compelling enough, conditional on whether they could navigate a system that was deliberately designed to exhaust and exclude them. From the racist disarmament codes of the Reconstruction era to the modern vampire rules that turned permit holders into presumed criminals the moment they stepped into a store, the intent behind these restrictions has always been the same. Control. Decide who gets to be safe and who does not. Keep the right expensive enough that the people who most need it cannot access it. What is happening in the courts right now is a direct repudiation of that entire framework. The Supreme Court is looking at the evidence, hearing the stories of real people who were failed by systems that were supposed to serve them, examining the data from states where the permit era ended without the predicted catastrophe, and arriving at a conclusion that should have been obvious all along. A right that requires government permission is not a right. It is a privilege that the government granted and can take back whenever the politics shift. The Second Amendment was not written to create a privilege. It was written to protect a right that exists independent of government approval, and the court is now treating it accordingly. The ruling expected this summer is going to be significant. It is going to be a turning point that gun owners will look back on for decades. But the moment that opinion is published, the real work begins. The workaround legislation is already being written. The follow-up lawsuits are already being planned on both sides. The state legislative sessions that will convene in response to the ruling are going to produce new laws, and some of those laws are going to require new court challenges. This is not a story with an ending coming in June. It is a story entering its most consequential chapter. That is exactly why staying connected to reliable, accurate information right now is not optional. It is essential. If you are finding the breakdown in this video useful, share it with every gun owner you know, because the mainstream media is either ignoring this story or framing it in ways that have nothing to do with your actual rights and everything to do with the political angle that fits their coverage model. The people in this community need real information, explained clearly and without spin. That is what this is here for. Hit that subscribe button and turn on notifications, because when the ruling drops, when the first state passes its workaround legislation, when the first follow-up challenge is filed, you are going to want to know immediately, and you are going to want it explained in plain language that you can actually use. Drop a comment below right now. Tell me what state you are watching from, what your state attorney general has said publicly, and what questions you still have after this breakdown. Your questions drive the next videos. We are going to keep tracking every development, every court filing, every legislative session, every state response, and every legal challenge from here all the way through whatever comes out of the Supreme Court this summer and beyond. The Second Amendment does not give you the right to bear arms. It protects the right you were already born with. The courts are finally starting to treat it that way. Stay informed, stay legal, stay safe.